Folks, breaking news. We have the decision from the federal judge in California. If you'll recall, Gavin Newsom sued Trump, the Secretary of Defense, Pete Hegseth, and others concerning the deployment of the National Guard and armed federal forces to LA and surrounding areas back in June. We know to date there's still 300 members of the National Guard that remain on site in LA, even though there's nothing going on there right now. But this is a 52-page order. And folks, I want you to stay with me when we walk through this. Why? Because as we saw this morning, Donald Trump, the convicted felon extraordinaire, has announced on Truth Social that he's eyeing Chicago once again as, quote, being the savior of that city by sending in troops. So people, the reason why this decision is so important is, as you've heard from constitutional law scholars like Steve Vladeck and others, this decision marks the kind of legal precedent that a lot of us are going to be looking to when we watch Donald Trump do exactly what he did in California in other cities and other jurisdictions like Baltimore, like in Chicago, etc. Remember, we've covered here extensively at this channel. DC is a unique, legally nuanced thing for Donald Trump. But California is on all fours with several other places in other states. And that's the reason why this decision is so important. So let's walk through it together, because it's important for us to understand the legal issues and the decisions and the fact-finding that went into this by Judge Breyer and why that impacts all of us across the United States. Alrighty, so let's launch this. So this is an opinion granting injunctive relief. As you all know, because you've been back to law school, right, with me, injunctions are blocks. These are blocks against somebody doing something. In this instance, Gavin Newsom asked for the judge to issue an injunction, both temporary and permanent, to stop the continued deployment of National Guard in his state. He also asked for other relief. In this instance, what the judge does is, right after the very beginning, the judge walks us through the procedural history of how it got to this point. But I don't want to skip ahead, because one of the best parts of this 52-page opinion is found right here. It says right here, Congress spoke clearly in 1878 when it passed the Posse Comitatus Act, prohibiting the use of the U.S. military to execute domestic law. Nearly 140 years later, defendants, President Trump, Secretary of Defense Hegseth, and the Department of Defense deployed the National Guard and Marines to Los Angeles, ostensibly to quell a rebellion and ensure that federal immigration law was enforced. There were indeed protests in Los Angeles, and some individuals engaged in violence. Yet there was no rebellion, nor was civilian law enforcement unable to respond to the protests and enforce the law. Nevertheless, at defendants' orders and contrary to Congress's explicit instruction, federal troops executed the laws. The evidence at trial established that defendants systematically used armed soldiers, whose identity was often obscured by protective armor, and military vehicles to set up protective perimeters and traffic blockades, engage in crowd control, and otherwise demonstrate a military presence in and around Los Angeles. In short, defendants violated the Posse Comitatus Act. Almost 3 months after defendants first deployed the National Guard to Los Angeles, 300 National Guard members remain stationed there. Moreover, President Trump and Secretary Hegseth have stated their intention to call National Guard troops into federal service in other cities across the country, including Oakland and San Francisco, here in the Northern District of California, thus creating a national police force with the president as its chief. Because there is an ongoing risk that defendants will act unlawfully and thereby injure plaintiffs, Governor Newsom in the state of California, the court enjoins defendants from violating the Posse Comitatus Act as detailed below. And there, my friends, is the sum of what Judge Breyer has decided. But it's important to get and drill down into some of the details, because the devil lives in the details, and I really want you to understand why this decision is of such import. As I mentioned just a couple of minutes ago, Judge Breyer walks through the procedural history. He did grant a temporary restraining order, but as you will recall, the defendants appealed that, and the Ninth Circuit did a temporary stay of Judge Breyer's order. So, With that pending, this temporary stay on the temporary order, restraining order, Judge Breyer very smartly proceeded to a, quote, trial on the merits, as it notes on page 3. A trial on the merits is actually getting to the heart of the matter. It is not, let's just deal with a temporary kind of issue. Let's not deal with the main meat on the bone. Judge Breyer said, let's have a trial. It was a bench trial, meaning no jury, just the judge. And over the span of August 11th to August 13th, this judge conducted a full-blown hearing. During that trial, he saw the introduction of evidence and he heard testimony from several witnesses presented by both the state of California, Gavin Newsom, as well as the defendants. In the end, the court's findings of fact and conclusions of law are found here. Now, let's just take a second and talk about what findings of fact and conclusions of law are. Findings of fact, pretty self-explanatory, right? The judge, not the jury, because this is a bench trial, is sitting there, and as the judge, he is listening to the witnesses. He's assessing the credibility, and he's taking in the facts as provided by the sworn testimony of these witnesses. In addition, because this is a bench trial, the judge is also looking at the exhibits that are being introduced into evidence, and he's considering those exhibits and those pieces of evidence. So his findings of fact take up a good portion of this 52-page opinion. Why? Because the man conducted a trial, and he wants us as the consumers of this opinion to understand what was the evidence that he heard and considered. What was the testimony that Judge Breyer heard and considered as he reached his decision? Conclusions of law. What the judge then does is he takes those findings of fact, he looks at the existing law, he applies those facts to the law, and he reaches his decision. So, another huge portion of this opinion are his conclusions of law, meaning based upon the facts that I heard, the findings I have reached based upon those facts, what is the law, and why did I decide this the way I did based upon the law? And that, my friends, is this 52-page opinion. So again, the findings of fact, which are Roman numeral 2, begin on page 3. And they're pretty extensive, but I want to highlight a few critical things that the judge heard and considered when he was going through this trial. So he mentions that the June 7th presidential memo that was issued by President Trump stating that he was deploying the National Guard into federal service in LA. He stated, I'm not invoking the Insurrection Act, he as in Trump, but I'm calling the National Guard into federal service to, quote, temporarily protect ICE and other U.S. government personnel who are performing federal functions, including the enforcement of federal law, and to protect federal property at locations where protests against these functions are occurring or are likely to occur. The man's prescient. He knows things in the future that we don't know. Then he authorized the Secretary of Defense, Hegseth, to employ any other members of the regular armed forces as necessary to augment and support the protection of federal functions and property. Judge Breyer notes this memorandum from Trump, on June 7th never specifically mentioned Los Angeles or California. And then Secretary Hegseth issued his own DOD memo on the same date of June 7th, where he called 2,000 members of the California National Guard into service. Then 2 days later, he issued another memorandum where he federalized an additional 2,000 California National Guard members. And then he deployed 700 U.S. Marines in addition to those 4,000 federalized National Guard troops and placed them under the control of Task Force 51, which is the U.S. Army North's deployable contingency command post. Alrighty? So, Judge Breyer notes that Task Force 51 underwent training specifically concerning the Posse Comitatus Act. And I love this because on page 7 of the opinion, the judge actually shows us one of the exhibits that was introduced at trial. What is this? What are y'all looking at on your screen right now? Well, this is a training slide that was used by Task Force 51 to be able to provide the training and the knowledge for these National Guard and other federal troops that were used in LA. And this slide is very clear. At the top, it says the following: prohibited law enforcement functions. And it lists specific law enforcement functions that are prohibited. You're not allowed to do these things according to the Posse Comitatus Act. PCA is what we'll call it, right? Because on the slide, it is called PCA. And it says PCA prohibits active/direct, and it says all of these things, right? And it says here in Judge Breyer's opinion, at line 21 on page 7, although the training materials list 12 prohibited functions, Task Force 51 troops were orally instructed that the 4 functions listed in red, security patrols, traffic control, crowd control, and riot control, were subject to a so-called constitutional exception to the Posse Comitatus Act. This instruction came all the way from the top of the Department of Defense down to Task Force 51. Here's the problem, though. There is no such thing as a constitutional exception, and we'll get into that in a second. Then it goes on to say here, the instruction was initially not put in writing. Isn't that always a big consciousness of guilt tell when you don't want to put something in writing, so you only say it orally? But then eventually, Secretary Hegseth issued a memorandum that explained the scope of this alleged constitutional exception to the Posse Comitatus Act in a June 23rd Department of Defense memo. And during the trial, what was outrageous is that the federal government took the position in front of Judge Breyer that there didn't actually need to be an actual threat to federal property, personnel, or functions to deploy Task Force 51, that the potential for unexpected threats was sufficient to deploy that task force, even where the military's own assessment is that the operation was low or no risk. And then the defendants pushed the envelope by arguing that even when there's no threat to the safety or security of federal personnel or property, the mere possibility that federal law enforcement might not be able to do their job justifies deployment of Task Force 51 as a, quote, preventative measure. Now, here's another thing that you wouldn't know about but for a trial taking place. Because argument is one thing, right? Caroline Leavitt spewing lies from the White House podium is another. Pete Hegseth and convicted felon Trump stating what they want on social media and publicly, whole other thing. But evidence is evidence in a trial. And this is what we learned through the sworn testimony of even the government's own witnesses. On June 10th, several days after the first Task Force 51 troops arrived in LA, a representative of U.S. Army North sent an email coaching, and that was the word that was used during the trial, coaching federal law enforcement agencies as to what language to use when submitting requests for assistance, which are how federal agencies requested support from these Task Force 51 troops. And it came from an email thread that was introduced into evidence. Specifically, this is page 10, law enforcement agencies were instructed to substitute protection for the word security, and to detect, monitor, report, you're supposed to substitute that for the word surveillance, right? And then it says here, if the requested activity cannot be converted to a protection term, then we cannot perform it. The Department of Defense did not explain what protection meant, nor did it clarify for federal agencies which functions troops could lawfully perform. The judge notes that these Task Force 51 troops wore military uniforms, which were green or in multi-camouflage. Some ICE agents also wore those camouflage uniforms as well. And the Task Force 51 troops were armed, carrying weapons with live ammo. So then the judge says that not only were operations taking place within LA County, but then if you can believe it, and actually before we get there to my next point, the judge notes that MacArthur Park show of force was just a sheer political theater. As we know, there were numerous rehearsals that were done, and you gotta love footnotes. So we love looking at footnotes as lawyers because the judges like to drop little Easter eggs and little gems in footnotes. And on page 12, there is no exception from Judge Breyer. Footnote 3 says, this operation at MacArthur Park on July 7th, which was called Operation Excalibur. Footnote 3, the judge says, Excalibur is, of course, a reference to the legendary sword of King Arthur, which symbolizes his divine sovereignty as king. We all know who he's referring to with that. And then footnote 4. Initially, Operation Excalibur was planned to take place on Father's Day. I just want you to stop and think about that. This park, which is known to be a place where a lot of immigrants convene, and there's kids playing, and during the summer there was a summer camp going on, as we know. Originally the plan was to do this operation on Father's Day. Really? What kind of lack of tact, nasty shit would that have been? But apparently the Major General Sherman, that's really his name, who was in charge of this Task Force 51, he objected, expressing concern that there would be a large number of people at MacArthur Park because it is Father's Day. To which Chief Bovino of the Department of Homeland Security criticized Major General Sherman for his opposition, questioning Sherman's loyalty to the country. I mean, this is how much fucking Kool-Aid these people drink, right? But then here's what's crazy. Judge Breyer obtained evidence during the trial that there were at least 3 operations for federal law enforcement that happened outside of LA County. So remember, the whole bullshit pretext of this was, oh, these riots and all this violence happening in LA, like the city proper, right? But in Mecca, Carpinteria, and Camarillo, Riverside, Santa Barbara, and Ventura counties, you had Task Force 51 troops being deployed to support DEA operations, for example, at cannabis farms, with no specific threat of risk or riot. And the judge notes that this is the use of these National Guard troops and Task Force 51 to be able to assist, even though this is way outside. I'm talking like one of these places, guys. Excuse me. One of them, for example, in Mecca, over 140 miles from downtown LA, Carpinteria, over 80 miles, and Camarillo, more than 50 miles from downtown LA, right? And even now, Judge Breyer says that you still have 300 federalized California National Guard members that are a part of Task Force 51, and that Hegseth has extended their deployment by 90 days. So they're going to be there till at least through here September, right? And that Trump has now threatened to basically deploy National Guard to not only, we know they're already in DC, but that he's also threatened to do it to Oakland, Baltimore, Chicago, and San Francisco, among other cities. Now, that was up until page 15. So, like I said, these are his findings of fact, pages 1 through 15. And then pages 16 through 52 are left to the actual conclusions of law. So let's quickly walk through those so you understand what was important. The judge emphasizes that it is emphatically the province and the duty of the judicial department to say what the law is, citing to Marbury versus Madison, which is a direct shot across the bow to Donald Trump. If the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so, citing to Trump versus United States. Yet another very kind of cool slap to Donald Trump. And here the judge finds that the Constitution may have given the president the role as commander-in-chief, but the Constitution gave to Congress, not the president, the bulk of the federal authority over the military, including the power to declare war, raise and support armies, etc. Then the judge walks through the history of the Posse Comitatus Act, which is important. And then he analyzes the fact that California does have an interest in how it participates in the federal system. So states have standing to bring lawsuits when they believe that the federal government has intruded upon areas traditionally within states' control. States also may have standing based on federal assertions of authority to regulate matters that they believe that they, as the states, control. In this instance, California and Governor Newsom have noted that the defendants violated the Posse Comitatus Act because it infringed on California's ability to exercise its own police power. And the police power is the quintessential power that the Constitution reserves to the states, citing to a United States Supreme Court case, United States versus Morrison. And listen, just in case you MAGA idiots think that Judge Breyer is just some crazy, unhinged, rogue judge, let me be clear. The judge then actually shoots down some of California's argument as to whether or not it has standing based upon impacts on the state's economy, as well as impacts on the citizens of California's health and welfare. He didn't just summarily give it to them. Let me be clear. Now, here's the thing. The judge makes it clear on page 26, the court is unaware of any person, government lawyer, military, or civilian official, court, or commentator who has ever made the following argument other than the defendant's lawyers in this case. That the president, when he federalizes the National Guard under a specific federal statute, 12406, that the president can do whatever he wants when he is unable to use regular forces to execute the laws of the United States. And the judge is like, no. Nobody has ever advanced that argument, and you're going to try that here in my court? And he says, hell to the no. In fact, the judge says even the own Department of Defense has never taken this particular position, that the president can federalize the National Guard whenever he's unable with regular forces to execute the laws of the U.S. He says the DOD has never even taken this position in its own publications dealing with the Posse Comitatus Act. And I'm going to fast forward a little bit. And the judge says the Insurrection Act doesn't give President Trump the ability to do this either. Even though the Insurrection Act is a recognized exception to the Posse Comitatus Act, none of the three avenues which are available for a president to deploy the National Guard or other branches of the military pursuant to the Insurrection Act exist here. So he says, sorry, you can't use that, even though, let me be clear, the defendant's lawyers, the government's lawyers, explicitly said that there was no invocation of the Insurrection Act. And then he walks through the test of the Posse Comitatus Act, and he basically says that the defendants have failed the test. And then he walks through the constitutional exceptions argument that was mysteriously, out of the blue argued. And he's like, this is the best part on page 34. The assertion of these constitutional exceptions is not grounded in the history of the Posse Comitatus Act, Supreme Court jurisprudence on executive authority, or common sense. He makes that clear. And then he walks through how the remaining arguments from the defendants lack legal authority and support. There's another great footnote 21 on page 41, folks. The judge notes that the protests in LA were large and, in some instances, violent. Local law enforcement is no stranger to such protests, though, and he cites to the Occupy LA movement, Black Lives Matter protests, and the sometimes riotous street parties which follow the Dodgers and the Lakers World Series and NBA championship wins. The June 6 and 7 protests were far more similar to these events than they were to the 1894 Pullman strike, which crippled interstate commerce across the western U.S. And that Pullman strike was what the government was saying was an example of how similar it was to what was happening in L.A. And the judge walks through Task Force 51's conduct, finds that it did explicitly violate the Posse Comitatus Act. And notably on page 45, Judge Breyer says that the defendants willfully, knowingly violated the PCA. Meaning it wasn't an accident. It wasn't like, oh, I'm sorry, I was well-intentioned, but it was an accident. The judge found that they not only knowingly contradicted their own training materials, which listed those 12 functions that you and I walked through on that training slide together, their own training materials barred the military from performing those acts, and the defendants did this while refusing to meaningfully coordinate with state and local officials. And the judge noted that the evidence showed during the trial that sometimes they didn't even coordinate with local law enforcement when they did some of their operations. Finally, the judge notes this. This is what makes judges like Judge Breyer very good. Because not only does he educate us on the history of these laws, the factual kind of background as to what happened here, and pretty much why, with explicit detail, the defendants violated the laws, but then he crafts the relief in a way that makes it very strong for purposes of appeal, meaning to protect California and to protect Gavin Newsom. So I'm going to read this to you. This is on page 51. The court's injunctive relief in this case is narrowly tailored to address the defendant's statutory violations. The injunction applies only to the defendant's use of the National Guard in California, not nationally. So let's stop for a second. Judge Breyer says this has nothing to do with other states or other jurisdictions and only has to do with the state of California. The defendants are not required to withdraw the 300 National Guard troops that are currently stationed in LA, nor are they barred from using troops that are consistent with the Posse Comitatus Act. In fact, the court essentially just orders the defendants to follow the unedited training materials that they introduced in this trial. Thus, for example, federal troops can continue to protect federal property in a manner that's consistent with the Posse Comitatus Act. So what does that mean? That means the judge is not trying to enter an injunction that goes beyond the borders of California, 1 and 2. The judge basically says the Posse Comitatus Act exists, but there are things that federal law enforcement can do that doesn't violate that law. And the judge basically says to the defendants, just abide by the law and you won't have a problem here. But of course, you and I both know that Pete Hegseth and convicted felon Trump are incapable of understanding that. And so inevitably, there's going to be yet another clash. But in the meantime, Judge Breyer's like, don't get your, panties in a bunch, defendants. I'm only basically telling you that you have to abide by what the statutory law tells you have to do. Period. End of story. The judge stayed this injunction, meaning he put it on pause until noon on Friday, September 12th, ostensibly for the government to go and seek relief from the Ninth Circuit. I can tell you this, and thus concludes this 52-page opinion. I would love for you guys to read this. There is some parts of it that are hyper-technical when it comes to the law, and yet it's still a good read. And the reason why I wanted to spend this time with you, and I appreciate you sticking with me, because I know this is a little bit longer than usual, is that this is now going to be looked at very carefully by other courts and other judges and frankly other states and other cities, etc., when they consider what Trump is about to do and is doing right now. You gotta love a well thought out, well crafted opinion from a federal judge. My hat off to Judge Breyer for this one. In the meantime, we're also tracking what's going to be happening in terms of Chicago and other states and other cities. So stay tuned here, and I'll always bring you the latest with a deep dive. See you soon. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.